On Wednesday, October 16th, 11 men have been sentenced to hang. They have been found guilty of starting a world war. Will their execution prevent future wars? What is the meaning of the Nuremberg Trials? This is the subject of the People's Platform today, as Chairman Dwight Cook welcomes three distinguished guests to Columbia's weekly discussion program. Our speakers are Oscar Ewing, noted attorney, Herbert Bayard Swope, former editor and reporter, and now alternate and co-worker to Bernard M. Baruch, U.S. Representative to the Atomic Energy Commission, and Quincy Wright, Professor of International Law at the University of Chicago, recently returned from Nuremberg, where he served as technical advisor to the American judge on the International Military Tribunal. For the People's Platform discussion of the meaning of the Nuremberg Trials, we hear first from Chairman Dwight Cook.
Many people, gentlemen, hope that these trials signal the end of one chapter in the history of the war and the beginning of a new chapter of a further development towards international peace. These 11 Nazis are going to hang for a new crime. At least they have been sentenced to be hanged for crimes which before that, so far as I know, no one was ever sentenced to be hanged for. So we have the broad question of the meaning of the Nuremberg trials, why we had them, and where they lead us. But before we can get into that, Mr. Swope, don't we have to cover a point that's been coming up in the press lately? How fair were the Nuremberg trials?
Well, in my opinion, Mr. Cook, the trials were not alone fair, but rested upon a base far, far greater than any mere legalism, and that is substantial justice. I'm afraid you're not going to get very far in disagreements here because we all seem to be thinking the same thing.
Well, if the same meaning is in all your minds, gentlemen, on these trials, all the better. Do you agree, Mr. Ewing, that the trials were completely fair?
Well, Mr. Cook, I think that there's no question that this particular trial is a thing that is contemplated by our own Constitution and was authorized by it. There's a provision in the Constitution that authorizes Congress to define and punish offenses against the law of nations. And the Articles of War specifically authorize military commissions to try violations of that law. And this tribunal that was set up by the President under that authority.
Well, now, Mr. Wright, as a professor of international law, how do you feel about Mr. Taft's statement? He does not seem to feel that these trials are fair.
I disagree with Mr. Taft, Mr. Cook. It seems to me that if Mr. Taft had anything to say, he would not be criticizing the tribunal, but criticizing the four powers that negotiated the charter. He assumed that they were making new law in this charter, and that consequently the tribunal, in applying the charter, was applying ex post facto law.
That is, law which was made up to fit a crime after the crime was committed?
Precisely, Mr. Cook. In my judgment, that is not a sound analysis. It seems to me that these offenses existed in international law before the German aggressions began.
Well, as a matter of fact, isn't it true, Mr. Cook and Dr. Wright, that we're not trying, those men were not tried for aggressive war. That was a cloak under which they committed crimes that are definitely specified as being antisocial. We were trying them for murder, for rapine, for theft. Isn't that the burden of it?
Mr. Swope, that was one of the counts, but I think we have to look at this thing legalistically, and there was an effort to carry out all of the requirements of fair trial.
With all due respect to the lawyers, Dr. Wright, I'd rather have an approach made to this on the basis of sound justice than mere legalism.
I would agree with you on that, certainly, but I think that carrying out the requirements of law is important in sound justice.
As well, Mr. Cook, you get to the. I think you get to the point that justice is what law says it is. There's no such thing as abstract justice.
Which comes first, Mr. Ewing? Well, justice, isn't it? We can have laws. We can have justice without laws. We cannot have laws without justice.
Well, Mr. Swope, if you're speaking of legal justice, that simply means justice as defined by law, and that's what you punish a man for.
Of course, you might have, Mr. Ewing, an unjust law. Would you agree to that? I think that the
It
laws
was a prohibition law.
the laws under which these men were tried was law, and it was also a just law.
Well, now, how about the acquittals from the positive sentencing of the 11 men? But the Russians, and I believe Mr. Jackson, a good many other people, were not satisfied with the acquittals of 3 of those Nazis. Was that a just?
Well, Mr. Cook, that's a question of appraisal of the evidence. There were 16,000 pages of evidence presented in this trial, as well as hundreds of thousands of documents. The summaries which were given in the press of the evidence seemed to me to indicate that the acquittals were fair, that the prosecution did not succeed in proving that these 3 men were guilty of the charges against them.
Well, Mr. Wright, under the law, they had to be convicted under evidence that proved beyond a reasonable doubt their guilt. And from the summary of the court that the court made of the evidence, certainly it would be rather difficult to say that they were proved guilty beyond a reasonable doubt.
And we must remember that they were being tried only on the counts which had been made against them by the prosecution.
Well, take the
They
case.
may have been bad characters, but they weren't being tried for being bad characters. They were being tried on particular charges.
Well, can't we dismiss that, Mr. Cook, by asking this question? What lawyer has ever been satisfied with a middle-of-the-road verdict? The prosecutor is unhappy, and the counsel of defense is equally so.
Well, I'd not like to dismiss it quite that fast, Mr. Swope, especially in the case of Fritzsche, Goebbels' assistant, one of the heads of the German propaganda system. A good many people say if a man like that is not guilty of crimes against peace, who is?
Well, the court found that Fritzsche had not been involved in the consultations for the initiation of aggressive wars. He simply carried out orders after the fact. That the crime of initiating or carrying out aggressive war involves being on the inside planning, and Mr. Fritzsche was not.
Mr. Wright, don't you think that we've got to keep clearly in mind here the 4 counts under which these people were indicted? The first one, as I understand, was a conspiracy among them all to have committed, or at least one or more of them, to commit the crimes that were charged in the other 3.
That is a
Now, the second count was the crime for starting an aggressive war. The third count was for committing crimes against
war practices.
War crimes.
War crimes. And number 4 were crimes against humanity.
Mm-hmm.
Now, the last 2 crimes have been crimes under international law for a long while. It's simply the crime of causing aggressive warfare is the new thing in this, and not the other 2. And it's interesting to me, Mr. Cook, that the only man that was convicted on the second count and the first count, namely for just starting an aggressive war, was Hess. And he was not sentenced to death, but only to life imprisonment.
Mr. Cook, I think there's an important point there in considering the reasons for the sentences. The only ones that were sentenced to be hanged were those who were found guilty of crimes against humanity.
Right.
That is, of wholesale
Third and
massacre.
fourth counts.
Those who were found guilty only of the conspiracy or of initiating aggressive war were sentenced to life imprisonment.
Aren't we arguing a question of degree instead of a question of principle? It seems to me that I, too, have been guilty of the offense of going to details instead of to broad elements. The question that the public must be convinced of is the essential fairness, the soundness, the precedental value of this trial. I happen to subscribe heartily to it. As I said before, these 2 gentlemen do too, and therefore, as agreement is always a death of discussion,
Well,
we
how-
have to find some other pretext to break.
How about the question, gentlemen, of the general staff? We read so much about how the German general staff was so responsible for this war, and yet the German general staff, as such, was not found guilty by the International Tribunal. Again, isn't that ducking part of the essential problem?
The tribunal's view was that an organization could not be found criminal unless one of its purposes was to commit one or more of these crimes, and that all of the members, or substantially all, were aware of those purposes.
Well,
Now,
surely the
general-
German General Staff was aware of the aggressive character of the war they proposed to wage, Mr. Wright.
It was
Wasn't
not
proven.
its purpose. Its purpose was not to wage aggressive war. It's different from the SS, for instance. The evidence showed that the purpose of the SS was wholesale massacre and extermination, and that all the members of the SS knew about it. So they found the SS.
If I can interrupt Dr. Wright a moment, if the implication of your question, Mr. Cook, is a special exemption granted the General Staff, I should be hardly opposed to it. But I find myself in complete agreement with Dr. Wright in explaining that the General Staff in the lower echelons were actually and definitely carrying out orders, and not in opprobrious manner. I mean, they weren't murdering people. The heads of the staff, we must not forget, Keitel and Jodl, were punished to the fullest severity of the law. I think that it is very unfortunate if we permit the privileges and the indulgences that have heretofore been given a professional soldiery, if that be continued. But I don't find it here, and I think Wright has made a perfect explanation of that.
I agree with you, Mr. Swope, and I think it's very important that the court gave a limiting interpretation of the
Right.
offense of an
Right.
organization. It's a novelty to find an organization criminal, and I think the court was right in giving a definition.
What about the
conception
antitrust
of
laws?
criminality, which would limit the application.
Well, how far down the line does that court interpretation take responsibility, Mr. Wright? If you're going to try to block aggressive war, and after all, that's one of the ends involved in all this set of international laws, if you're going to try to do that, how far down the line does the court say you may go in convicting people of waging an aggressive war?
Well,
if
but
the
Mr.
chief of staff is guilty, is his assistant guilty, are his chief generals guilty? How far down does it go, Mr. Ewing?
Mr. Cook, what happened here is that the purpose of finding these organizations guilty was so that when you start in to try the individuals, all that you had to do to convict them was simply to prove that they were members of the organizations and knew what the purpose of the organization was. Now, any of these people that you mentioned can still be punished for their individual crimes. It is simply that the merely being members of the organization doesn't make it criminal.
That's a very good point, Mr. Ewing. The members of the organizations have an opportunity for individual trial to show that they actually were members of the organization and they actually were aware of its criminal purposes.
Just as Mr. Swope pointed out, that Keitel and many of the other top men, Jodl, were actually convicted.
Well, there are two different sets of trials still to be involved for some of these men, aren't there, gentlemen? On the one hand, trials under the blanket indictment, and on the other hand, trials in national courts as Schock and von Papen, for instance, seem to be facing.
Well, the trial which has been suggested Schock may have to endure yet is for being a Nazi under certain denazification laws that have been passed in certain of the German provinces. That's, of course, something quite different from the charges in this major trial.
Well,
I
now,
personally don't believe that we need pay much attention to that, because it seems to me, as a reasonably intelligent layman, that the principle particularly dear to us of the Anglo-Saxon persuasion of double jeopardy would play an enormous part. And you can see that the essential fairness of the trial, which was the first point you touched upon in your interesting opening discourse, Mr. Cook, was the fairness of the trial. They thought it fair. They thought they had it. Not one, only one denied jurisdiction. That was Hess. Is that right, Dr. Wright?
Yes, well, Hess really said eventually he wanted to be tried.
Did he?
Yes.
And the rest appealed to us for protective incarceration.
His lawyer tried to make out that he was he lost his memory or was feeble-minded and consequently couldn't be tried, but Hess himself got up and said
What was the truth of that? Did you think him a nut?
No, I think that Hess had some losses of memory, but I think that in the situation he was in, he was capable of being tried in a legal sense.
well, now there seems to be a rather encouraging unanimity on the fairness of these trials. So let's look at the second question here, why we had them at all. Certainly, one of the very important reasons was the effect they would have on the German people, wasn't it, Mr. Ewing?
Yes, well, the purpose of any, there are two purposes of any criminal trial. First, to punish the man for his acts, and second, as a deterrent against other people repeating the act. And certainly these trials are justified on the first grounds of punishing these people, and secondly, it's certainly hoped that it'll be a deterrent.
Well, watching those in operations, Mr. Wright, did you feel that they were acting as the Germans watched them? As I understand, the trials were very widely publicized throughout Germany. There were special newsprint for them. There were special recordings. Do you feel the German people have learned a lesson from them?
I think they have. I think one of the great importances, Mr. Cook, of the trials was the evidence which it gave great publicity to on how the Nazis started and what they did. And I think that's of great educational value. But I want to make one point in connection with what Mr. Ewing was making, the deterrent influence for the future. It seems to me can be considered in two lights. In the first place, future leaders who may be contemplating aggressive war will realize that they're assuming a considerable personal risk. And secondly, the broad publicity these trials have given to the notion, which has been widely accepted in the world, that aggressive war is a crime, will influence public opinions. There will be a greater moral sensibility among the publics in any country that it's wrong to engage in aggressive war.
Mr. Cook, I agree with Mr. Wright on that. After all, what the effect on the German people or on other nations or individuals planning aggressive warfare will be, we can't say. But there has certainly been over the last 100 years, particularly, perhaps longer, an attempt to get away from war and create a public opinion that makes war abhorrent. Now, what'll do that? You've just got to try one thing or another, just as I think it was William James said that you don't get to the kingdom of heaven by sailing before the wind. It's first one tack and then another. It's a headwind.
As a matter of fact, it seems to me, Mr. Ewing, that the effect of trials is very pronounced if we judge by history. And after all, records stand, opinions die. And interesting as mine may be, as Wright's may be, as yours may be, it's somewhat metaphysical. I think it's difficult to answer the question. It has been said, and truly said, that only the victors can be the judges.
Well, isn't that what
true.
happened here at this tribunal? The victors
But there's no
judged.
other method, is there? It's at least a beginning. There may be some international tribunal erected.
A good many people have asked why not have the United Nations try these people, Mr. Swope.
Well, do you know that 23, including practically all those who were either participating or close to the scenes of conflict, have agreed to the London Declaration? 23 is a good beginning.
Well, you can also recall that after the First World War, it was provided that the Kaiser and some of the others should be tried, but that trial was left to the Germans themselves, and they were never even brought to trial.
What about Napoleon?
Well, he wasn't tried.
He was exiled summarily.
That was a political
But
decision.
I think it does have some bearing upon this.
Well, then, to what extent is this
Thank you.
set of trials a new thing? To what extent is this a creation of a brand new precedent? Is it something that has never happened before? And how far?
I would say, Mr. Cook, that the new thing is the recognition of the principle that an act of state which is unlawful cannot give an immunity to an individual. The Pact of Paris made the initiation of aggressive war unlawful, and consequently individuals who start an aggressive war can no longer claim the immunity of act of state. That, I think, is a very important principle,
Well,
not
you mean
entirely novel, but established by this trial.
After the First World War, that Hindenburg could have claimed such an immunity and not been tried?
At that time, there was no Pact of Paris. It was lawful for any state to go to war for any reason. And consequently, Hindenburg could claim that it was an act of state, and he was personally immune. That's no longer the case, and that is a very important development, a development which is in accord with the principles of the United Nations Charter, and which I think will have great effect in the future.
Of course, I'm not sure whether the fact that that here we are for the first time trying those who perpetrate aggressive warfare is the real, to me, the real thing, and that it's only incidental that the defense has been eliminated, although that certainly is a very important corollary.
Let me make this point, Mr. Ewing, that we have tried in American courts individuals who have set on foot filibustering expeditions. That is, they started out from American territory and made a military expedition in Cuba or Nicaragua or somewhere, and they've been found guilty. Well, now, from the material point of view, that crime, which has been tried throughout American history, is exactly the same as aggressive war. But in the past, when a person committed such a military expedition under the authority of his state, he had a personal immunity.
I want to go back a minute, if I may, Mr. Cook, and attack you. I think the analogy that you brought up between Hindenburg and the recent commanders of the Nazis is unfortunate because it brings a connotation of likeness, of equality. The crimes charged here were unthought of by in the last German war, and that was bad enough. But this was vast enslavement. This was enforced prostitution. This was murder, torture, rapine, and the stealing of lands without the encumbrance of their population.
Well,
these are crimes specific and definite, which they committed under the cloak of an aggressive war.
We must make the distinction which Mr. Ewing made, Mr. Swope. A man like Hess, for instance, was not found guilty of these other crimes, this wholesale massacre. The only thing that he was found guilty of was conspiracy and the initiation of aggressive war. He was sentenced to life for that. And that's the thing that Mr. Ewing and I were talking about, that it does bring in this crime wholly apart from the other things which were so terrible and which most of these people were found guilty of.
Well, another question that comes in here, again, is a matter of degree, perhaps, but a very important degree, and that is this question of how far you can switch over from the active to the passive. Now, under these Nuremberg trial decisions, you are able to try the leaders of a state who commit aggressive war. Now, suppose the leaders of those states have very good friends who are the leaders of other states who are tacitly fighting that war, although they do not fight it on a battlefront, by supporting in every conceivable unmilitary form the waging of that war. Have we any way internationally of reaching those culprits?
Well, it's a question, Mr. Cook, of what evidence you take, you require to establish guilt of these crimes. How remote you can make it. And
well, how remote can you make it, Mr. Wright?
These persons, we find, were all except three found guilty. The court found the relationship to the offenses was too remote to find them guilty. Of course, that's something the criminal court always has to do. How remote is the acts they committed to the crime?
Well, digressing a moment on the question of jurisdiction, on the question of accepting the authority of the court, may I point out to you that trial and punishment has been applied against the demurrer of the defense in a very remarkable book written perhaps 100 years ago by George Burroughs, now in the public domain, so I can't be accused, Mr. Cook, of putting in a plug, celebrated trials in criminal cases. Mary Queen of Scots, as you two eminent gentlemen of the law will remember, declined to accept jurisdiction and insisted upon being tried by a jury of her peers. She was tried and, I think, beheaded. Napoleon, as Dr. Wright just now said, was summarily exiled, and there's no difference between exile and death, except the one it's inflicted upon, but it's a principle that's present.
But Napoleon, Mr. Swope, engaged in a very active and readily perceptible aggressive war. I'm raising the question of what recourse...
What evidence on that point?
What?
Well, Mr. Swope,
the Russians.
Mr. Swope, I think in so far as Napoleon was concerned, there was no attempt of a legal trial there. That was purely a political decision.
A hue and cry. I agree.
Well,
then this is a step in advance, isn't it?
Exactly.
Well, then we're all together.
I think that's the
By the
point.
way, if we're all agreeing, how do you spell Nuremberg? I've seen it spelled 3 different ways in America.
Mr. Wright, you were there last. I think
Well,
you
I
can
think
spell
the
it.
English spelling is N-U-R-E-M.
What's the American spelling?
but the German spelling is N-U-E-R-N instead of an M.
The Times,
It'd be done either
Herald
way.
Tribune, Columbia Broadcasting all spell it separately.
Well, however we spell it, gentlemen, I'm interested in how far we can go along the trail that the Nuremberg trials have blazed. If we cannot, and you would seem to be agreeing, although you have not said so flatly, if we cannot reach into a country which has not waged aggressive war yet, we're a long ways from being able to cope with war, are we not?
Mr. Cook, I think we have to move forward. If the powers, and as Mr. Swope pointed out, there are 23 of the United Nations signed this charter. If they believe this principle, the next step should be to set up a permanent international criminal court with jurisdiction to try anyone who is guilty of one of these offenses or any other offense against the law of nations.
Well, but does that mean that it's always after an aggressive war is finished and after the vanquished are vanquished that we try them?
No, I don't think so. We might have an international tribunal in which I have no doubt Dr. Wright would be a fitting member. I'd like to say this last word so far as I'm concerned, and not the last word Mr. Justice Jackson refers to. If we achieve justice, we shall be well on our way toward world security, because a few moments of doing real justice is better than a lifetime of pious intent.
And that leaves us with the question of how much more real justice we have to do, Mr. Ewing. How about the whole question of propaganda in the future? Surely people who are whipping up their people toward hating other people and toward aggressive wars are contributing and making such a war less unlikely. Is there any legal or international way that we can stop that?
Well, that's a thing that's got to evolve. Things today are regarded as crimes that were not regarded so 100 years ago. You have a moral evolution, and we've gone a long way here. We're stepping in the right direction, and let's just hope that we can keep society going that way.
I'm glad you made that point, Mr. Ewing. I think it's important to realize that international criminal law can develop satisfactorily only as the common law did. Our ordinary crimes of murder and rape and arson were developed through judicial decisions.
And no statute.
If we could get a permanent international tribunal, we could get a development of international criminal law, which I think would be a great value.
But, gentlemen, that's a very slow process, and the atom bomb and bacterial warfare is a very fast process.
This point, I think, should be made, that, as I understand, Mr. Swope can correct me on this, both Mr. Baruch and Mr. Gromyko are agreed that there should be an individual responsibility for offenses in connection with the atom bomb.
Right. Except they want to establish that responsibility insofar as the Russians are concerned by a series of nationalistic efforts. And we, America, thinks that it should be an international inspection, and we'd be the most inspected of all.
But both of them use the word that it should be a crime. I think it should be an international court that tried it.
That's our point.
Well, gentlemen, you've agreed to a very large extent on the meaning of these trials. It seems to me that in all your minds, you have been making the point that we face danger from war in such stark forms from here on, that it's a question even of survival, that we've got to learn the lesson of learning how to protect ourselves from those wars, and that the Nuremberg trials have showed a real glimmering of hope, a concrete and a tangible stirring of world conscience against the world crime of conspiring for total war. As Justice Jackson said, it's for the statesmen to pick up where the lawyers left off, and most of all, perhaps it's for the peoples to help the statesmen pick up.
You have been listening to the People's Platform, Columbia's weekly discussion program, as it considered the question, what is the meaning of the Nuremberg Trials? Chairman Dwight Cook had as his guests Oscar Ewing, noted attorney, Herbert Bayard Swope, former editor and reporter, and now alternate and co-worker to Bernard M. Baruch, U.S. Representative to the Atomic Energy Commission, and Quincy Wright, Professor of International Law at the University of Chicago, recently returned from Nuremberg, where he served as technical advisor to the American judge on the International Military Tribunal. We invite you to be with us again next week at this same time for another discussion on the People's Platform. People's Platform broadcasts of particular interest to servicemen and women are broadcast overseas through the courtesy of the Armed Forces Radio Service. This is CBS, the Columbia Broadcasting System.